Hello, my name is Paul Chang, and today I'm going to be explaining to you HR 6201. I do want you to know that there are many employers that would have been impacted by HR 6201, but what they've decided to do is close down. And there's a reason for that. That is the benefits that will be coming out through HR 6201 are too difficult for many employers to handle. There is mass confusion as it relates to the federal law that's been passed, as well as many of the state leave laws, particularly in California. So many employers have decided that the best course of action is to close down. What is HR 6201? HR 6201 was passed on March 18th, 2020, and he essentially stated that within 15 days or earlier, that a specific law was going to be passed to give benefits to employees. Now, there are other provisions in HR 6201, but there are only going to be two things that we're going to be speaking on today. The first one is the amendment to the FMLA, and that occurred in Section C of HR 6201. And the second one is the more popular Emergency Paid Sick Leave Act. So what is FMLA? FMLA essentially says that if you've worked for an employer for the last 12 months and essentially you've put in 1,250 hours of work and you have over 500 employees, if you have a serious health condition or you need to take care of somebody in your family, you can be able to get 12 weeks of unpaid leave. But what is HR 6201 as it relates to the FMLA? The FMLA is traditionally for employers that have 50 employees or more. Well, now what the HR 6201 does is replaces 50 or more employees with 500 or fewer employees. So it has expanded FMLA. Now, I do want you to know that my analysis of HR 6201 in the amendment to FMLA is slightly different than other attorneys, as well as the written labor commissioner. The labor commissioner has said that they're going to put out new rules and regulations, but some of the analysis that's occurred is different than the plain reading of the statute. So what does the statute says in terms of the amendment to FMLA? What it says is that if you are affected by the coronavirus, you need to take care of take care of a family member, or you need to take care of a child, you can get up to 12 weeks of 2/3 of your regular rate of pay, up to $200 a day, up to $10,000, up to 12 weeks. However, the first 10 days are unpaid. Now, I do want to say the plain reading of HR 6201 says the first 10 days are unpaid. However, when I've gone onto the Labor Commissioner website, it's stated that the 10 days don't exist. So a lot of employers are very confused. Within the amendment to the FMLA, it says that if you are under 50 employees, the Labor Commissioner can exempt you. Now, what a lot of companies have said is if we're under 50 employees, we don't give the benefit, but the plain reading of the statute seems to suggest that the Labor Commissioner is going to do more. Now, I do want to say that today is March 29 of 2020. We believe that by March 31st of 2020, which is this upcoming Tuesday, the Labor Commissioner is going to be putting out more rules and regulations to interpret HR 6201 for purposes of 50 employees or less. The second amendment, which is the one that everybody has talked about, is what's called the Emergency Paid Sick Leave Act. Now, that's very different from the amendment to the FMLA, so we're going to put the FMLA amendment aside. This one says that if you have under 500 employees or less, and you are subject to a quarantine, or you need to take care of a child or a person exposed, you get up to 80 hours of your regular rate of pay, maximum of $511 a day, with a maximum of $5,110, and the other one says $2,000, which really gives you a total of $7,000. Now, there is an exemption in there for a viability of a business. He essentially says that you don't need to pay it if paying it would be detrimental to your business. It provides for a exemption for companies that have 50 employees or less. But for both of the regs within HR 6201, it does say that for the employee to have that benefit triggered, is that the employee needs to show that they cannot work or telework. So a lot of employees have thought of HR 6201 as a vacation benefit. It is not. It is a benefit that is provided by the employer through the federal government if the employee cannot work or telework. In my opinion, the employee needs to be able to prove that. I do want to say that there's confusion as to whether employers that have given out this benefit will be entitled to a federal compensation or an offset. I'm not an accountant, but essentially what it says is that businesses will receive a 100% tax credit equal to the qualified leave that's being given. But what have a lot of businesses have done? They've essentially said, we don't need a tax credit. We're not making any money. And so they've decided to close, because obviously you have to be an employee on April 2nd to be able to receive this benefit. Using HR 6201, I do want you to know that just because you're an employer in California, and although there is a federal rule, does not mean that you do not need to comply with California statutes. And California statutes are many. There are about 10,000 ways that an employer can be sued. But I'm going to give you the basics as it relates to leave law. The first one is under the DFEH. The DFEH requires a reasonable accommodation. A reasonable accommodation is just that. It needs to be reasonable. And if you have 5 employees or more in the state of California, you must provide for reasonable accommodation for employee needs. Another one is pregnancy disability leave. If you have 5 employees or more, you need to understand that if you have someone that is pregnant, you need to provide 4 months of unpaid leave so that your employee can be able to take care of themselves if they are pregnant. Another one is CFRA, FMLA. We talked about FMLA earlier, but CFRA provides for even more protection. And what that means is that if an employee needs to be able to take care of somebody under the CFRA, you need to provide 3 months. So essentially you can have pregnancy disability leave for 4 months with another 3 months under CFRA for a total of 7 months, which are unpaid leave. Now, California provides everything as unpaid leave, but again, you have to remember HR 6201 now provides for paid leave. If you are an employee that has been affected, I do want you to know that there are several California benefits that you can be able to look at. If you've been affected by coronavirus and it's due to your work, for example, you had a coworker that got sick and now you are sick, you are able to get workers' compensation insurance. Workers' compensation insurance. Another one that you should be looking at is state disability insurance. A lot of employees don't know this, but a lot of times you can be able to get both workers' compensation and SDI, which is state disability. Every month, on a monthly basis, there's portions of your tax returns that a lot of deductions on there, you can't be able to read them. Employers have that too. Well, a portion of that goes to what's called state disability insurance, and that's something that you can be able to look at as well. Thank you very much. If you have any questions, please let us know. Call our law office, or you can be able to contact me directly at the campaign office at area code 626-531-0912, 626-531-0912. Thank you very much. I'm Paul Chang.